Hello and welcome uh, to this panel discussion on the Affordable Care Act in the Supreme Court. I'm Jim Blumstein, University Professor of Constitutional Law and Health Law and Policy, and Professor of Management at the Owen Graduate School of Management and Director of the Health Policy Center here at Vanderbilt. And it is really my honor to serve as the moderator for today's discussion, which will focus on what is currently in front of the Supreme Court for the Affordable Care Act, potential decisions and outcomes and their effects. And we have a wonderful panel that I'm privileged to moderate, and I'd like to introduce you to them. But we're going to keep the introductions short, even though their CVs are very, very long and distinguished in all cases. First, my colleague Ingrid Wuerth, who's the Associate Dean for Research at the law school and the Helen Strong Curry Chair in International Law, and she's director of the Cecil D. Branstetter Litigation and Dispute Resolution Program and a favorite among students for her prowess in teaching. Kitt Carpenter is the E. Bronson Ingram Chair and Professor of Economics and Director of the Program in Public Policy Studies and a wonderful health economist in the Department of Economics. And Dr. Melinda Buntin, who is the Mike Curb Chair and Professor of Health Policy and Chair of the Department of Health Policy in the Medical Center and a distinguished national figure in health policy and who's really built up that department in a wonderful way with wonderful colleagues and great productivity. Um, Now we're going to hear from each of the three panelists' perspectives on their view of the case and of the Affordable Care Act, and then we'll move to questions and answers, including questions that you have submitted, which have helped shape our discussion today. And as moderator, I'm going to start very briefly with kind of a little bit of an overview of the case and the background, and then we'll move to Professor Wuerth, to Professor Carpenter, and then Professor Buntin in that order. So let me take a few minutes to go through this. I want to make 5 quick points here. First, I want to say a word about how insurance markets work. Insurance markets, in insurance, there's a pool of money to fund the needed services. And the rule of thumb is that 80% of premium payers fund about 20% of those in the pool who need more care. And there's an incentive in the marketplace to join the pool, because if you don't join the pool and then you become ill, you're not eligible to enter the pool. This is the problem of pre-existing conditions. Markets work because the incentives, if it's too late to sign up, if you get sick, you don't get the benefit of being in the pool. And the idea is that you're glad to be in the pool, even if you don't need the services. In fact, every year, January the 1st, I thank God that I didn't get my money's worth out of my life insurance premiums. I never feel cheated about losing out on my life insurance premiums. The second point, the Affordable Care Act rejected this outcome of excluding people with pre-existing conditions from eligibility and from paying higher prices. And the architecture of the Affordable Care Act is built upon certain social policy goals, that it was important to cover those with pre-existing conditions and at reasonable prices. This is called guaranteed issue, that insurance companies must issue a policy even to those who have pre-existing conditions, and not to charge higher rates for those who have those conditions. This is called community rating. The problem is that this diminishes the incentives to buy insurance and to fund the pool. And so in the market, there are incentives to join the pool. The Affordable Care Act recognized that the diminution of these incentives could create problems of funding the pool, and it substituted coercion for market incentives, and thus was born the individual mandate that required people to buy into the pool and help to fund it. Third, the NFIB decision from 2012 was a challenge to the many things, but specifically to the individual mandate. Under federal constitutional law, the federal government needs a source of authority before it can act. And so therefore the question was, what's the basis for the individual mandate? And the court rejected the Commerce Clause and the Necessary and Proper Clause as bases for the individual mandate. But then Chief Justice Roberts, for a majority, upheld the individual mandate as a tax because it raised revenue. And the individual mandate is not a mandate, but a choice. And the court read this into the statute, called it a savings construction. In order to make the law valid as a tax, they had to, in a sense, recast or interpret the law so as not to be a mandate, but to be a choice. You can choose to buy insurance, then you're free and clear, or you could reject the insurance and then you would pay a tax instead. Now, this becomes a problem after 2017. The tax legislation that was passed in 2017 reduced the tax to zero. And since the court had said a tax has to raise revenue, it became a question whether the tax could any longer serve as a source of authority for the individual mandate. The challengers say that the individual mandate is no longer valid because there is no source of authority. There's no taxing was the only source and there's no taxation any longer. If the individual mandate is not valid because it's not a tax and it doesn't satisfy the requirements for Commerce Clause or Necessary and Proper, then that goes down. But then the important questions are severability. What other parts of the law stay and which ones go away? And the Justice Department initially said it could defend the law, but the community rating and the guaranteed issue would have to go down. Later, the Department of Justice changed its view, said the entire law was invalid, and then the Biden Justice Department has backed away from the Trump administration position. And that kind of sets the table for where we are in terms of the background and the present issues and reality of where the court is and where the case is. So I will turn to Professor Wuerth, and Ingrid, it's yours.
Thank you so much, Jim, and to everyone who convened this panel and to my esteemed co-panelists. It's really an honor to be here. Jim's already introduced the main issues. I want to introduce the litigation a little bit more. In terms of the litigation, the 2017 congressional amendments to the Affordable Care Act that set the penalty for not buying health insurance at zero, and that same act of Congress that left the rest of the Affordable Care Act in place, that makes this a really complicated and difficult case legally, actually, in terms of all of the issues, and the fact that the Supreme Court has already weighed in on the Affordable Care Act, as Jim said. So the issues get complicated and technical really quickly, but I'll do my best with an overview here. So Texas, and along with a bunch of individuals, went to federal court after the 2017 amendments, and they said, look, the penalty for not buying health insurance is zero, and therefore this isn't a tax. And therefore, as Jim said, the ACA is unconstitutional, and the mandate is such an important part of the Affordable Care Act that the entire rest of the law has to be struck down as well. That's the severability point that Jim mentioned. So interestingly, California and some other states joined the lawsuit, and that's why this is called Texas versus California. They joined the lawsuit to defend the individual mandate and the Affordable Care Act. So we have states on both sides here. The district court in Texas held the mandate unconstitutional and said the entire Affordable Care Act should be invalidated. The Fifth Circuit upheld the district court's conclusion that the mandate is unconstitutional, but then was going to remand for more decision-making on the severability point. And the Supreme Court granted cert, and there are three distinct issues, right? Is the mandate constitutional? And if the mandate is not constitutional, what happens to the rest of the Affordable Care Act? And then this threshold question, is there even any standing here? Is there even the legal right to sue, given the penalty for non-compliance here seems to be zero? So on the constitutionality argument, is the mandate constitutional? There's basically two arguments that it is still constitutional. One is that it's still a tax, right? So it was a tax because it produced revenue for the government. And that aspect of the the individual mandate is no longer there. It doesn't actually produce any revenue for the government. So can it still be a tax? The argument goes that, look, it's still part of the Internal Revenue Code, right? If you still turn to the Internal Revenue Code, this is still in there. It provides a statutory structure through which Congress could eventually tax people. And it still includes some references to taxable income, joint filing status, and the mandate doesn't apply to people who pay no federal income tax. And so it's kind of mixed up with all this tax stuff. The lower courts didn't accept that argument, but it is still an available way for the Supreme Court to uphold the individual mandate. The other argument is, and this is a theme in a bunch of the legal issues here, is, well, like, how can Congress be exceeding its powers if it just reduced the tax to zero? It's not really a mandate anymore. It's not really telling anyone to do anything. And so how can this be unconstitutional? So those in broad strokes are the two arguments kind of on the merits, right? Is the individual mandate with a zero penalty still constitutional? The other arguments actually took up a lot more time at oral argument and a lot more time in the lower court's decision making. The one that we've mentioned is whether the mandate is severable. To some extent, this is a question of legislative intent. And it seems like Congress wants the Affordable Care Act to survive without the mandate, because that seems like it is exactly the statute that they created when they zeroed out the tax, right? So they zeroed out the tax, so the individual mandate didn't work, but they wanted to keep the rest of the statute in place. That seems like Congress wants this to be severable. On the other hand, challengers argue that you really need a scalpel here, and the statute has a lot of interlocking pieces, and the drafters of the statute always emphasize that the statute works together as a whole, and we can't pick off little pieces of the statute and expect the statute to function in the same way. Those arguments would suggest that it is not severable. So on the third point, and I think we'll talk a little bit more about this in Q&A, if the challengers lack standing, the way it works in our system, the whole case is resolved on that basis. The justices won't reach the merits of whether it's constitutional. They won't necessarily reach the question of severability. And standing depends both on the nature of the injury to the plaintiffs, and we have different plaintiffs here that allege different kinds of injuries. Standing also depends on the relationship between the injury and the litigation itself. So I'm gonna stop there. We'll take up standing in Q&A. Thanks so much for the opportunity to be here.
Kitt, go for it.
Thank you, Jim. Thank you for the invitation to be with you here today. I'm very grateful and humbled, but also intimidated, because the degree of expertise for the other panelists on here is immense. So I am not a lawyer, so I cannot speak to severability or these other interesting legal entanglements, and I'm not a health policy expert like Dr. Buntin. I am a health economist. So when I think about how I can be helpful to today's conversation, I thought I would kind of step back and kind of summarize what we know and how we know what we know about some of the provisions of the Affordable Care Act, some of which could go away if in fact the whole thing is dismantled. So we are now 10, 12 years out from the Affordable Care Act. So health economists and health services researchers, including some folks that you see on the screen, or we'll see in a minute, have contributed to a now immense literature of hundreds and hundreds of published studies looking at different provisions of the Affordable Care Act. So I just want to talk about three of those. So One is the dependent coverage provision or the young adult mandate. The other is the Medicaid expansion, and the final one is the preventive services provision. So one thing that happened right when the Affordable Care Act was started, before kind of the Medicaid expansion and marketplace reforms, was the young adult mandate that took place in 2010 and said that young adults could stay on their parents' insurance coverage up to age 26. So there was a patchwork of state legislation prior to the ACA, but one thing that this provision did is it allowed health economists and health services researchers to look very clearly at effects on coverage, utilization of care, and health by comparing the outcomes of, say, 20 to 25-year-olds over time to the associated changes for, say, 27 to 31-year-olds. And so this line of research very clearly shows that some of the biggest coverage increases from the ACA were from young adults. So you see immediate reductions in uninsurance rates, i.e. increases in insurance for those young adults that were able to ask their parents to stay on insurance. You also see increases in access to care and some improvements in self-rated health. The same is true actually when you look at Medicaid expansion, which was another big pillar of the ACA that took place several years later. So one reason we know so much about Medicaid expansion under the ACA is because only some states did it, and states varied in when they did it. So this gives rise to a very kind of internally high fidelity set of designs whereby we can look at outcomes across people in different states based on their coverage expansion decision and look at things like insurance coverage and utilization of care and health. And I'm going to put something in the chat because I think there's this one study that's kind of proof positive of all of the literature out there in the journal called Quarterly Journal of Economics, which is arguably the most important journal in our discipline. And these studies very clearly show that coincident with expansion, you see big increases. And in addition to this, within the states, we have very clear predictions about who within the states should have improved coverage and access, because there are very clear income limits, for example. And so you can go into survey data and ask, do we see that for the people who we should have seen get improvements precisely at the time that there was an expansion, you see these improvements in coverage, you see these improvements in healthcare access, and you do. And the study that I put in the chat, I think is kind of the cream of the crop, because a challenge with many studies in health economics and health services research is like, what are the health outcomes and what do they really mean? So one that's like unambiguous is mortality. It's much better to be alive than to be dead. And this research team, Sarah Miller, Laura Wary, and co-authors linked survey data to very high fidelity death data. So they can see that coincident with the timing of the states that expanded relative to the states that didn't expand, you do see reductions in mortality that are very precise and very clear and centered in the group who should have received kind of expanded coverage. So these are the types of coverage, utilization, and health outcome improvements that are at kind of risk or on the table. We're kind of there to be a wholesale dismantling. The last thing I'll say is the preventive services mandate. So also in 2010, what we saw is kind of the requirement that health insurance plans cover a variety of services that are kind of commonly understood to be high value care from the United States Preventive Services Task Force, that these be covered in your insurance plan without cost sharing. So from work that others have done, including myself, we know that kind of even very small barriers can actually, small cost barriers, can have big effects at reducing people's use of preventive care, including high value preventive care. So there's quite a bit of evidence that kind of removing those barriers can help improve access to care and actually narrow disparities that have previously existed in coverage and utilization. And that's just 3 examples. And with that, I'm happy to turn it over to Dr. Buntin.
Great. Thank you all so much. And thank you, Jim, for inviting me to be part of this panel and saying such nice things about my department, which really was founded at about the same time as many of the provisions of the Affordable Care Act went into place. So we've been looking in the Department of Health Policy at the effects of the Affordable Care Act. And I just wanted to sort of take a step back to the period of time when it passed, which is over a decade ago now, right? We're past the 10-year mark on the Affordable Care Act. And realize that it really was a signature piece of legislation during a presidential term that marked a turn towards the really bitter partisanship that we've experienced in recent years. And that has colored all of the implementation of the Affordable Care Act and has also made cases like the one we're discussing now so fraught, both legally politically, as well as practically, when we think about how the Affordable Care Act has touched nearly every aspect of the healthcare industry, which is nearly a fifth of our national economy. So this is enormous. I also like to look back at the Affordable Care Act and say it's so ironic that it's such a source of partisanship, because it really set out to address problems that Americans still, in overwhelming numbers, want to see solutions to. And because it did so by building on a framework that was constructed by Republicans as an alternative to the Clinton health plan in the 1990s. And to add a layer of irony to all of this, candidate Obama, during the presidential campaign, actually did not include in his plan an individual mandate. Candidate Clinton did, but candidate Obama did not. His economic advisors told him it was not a necessary component, that in fact, if the subsidies for purchase of insurance were generous enough, as Jim explained at the beginning, we would have adequate incentive for people to buy into health insurance markets or participate in health insurance markets, and we wouldn't need a mandate. And in fact, I would argue, again, talking about the legal aspects of this, that what we've seen since 2017 is empirically, so I'm not talking about legally or theoretically, but empirically, the individual mandate has, for all practical purposes, been severable, because the health insurance markets to which it would have applied continue to function. Insurers continue to offer policies in those markets. Consumers continue to buy insurance in those markets, even though the penalty was zeroed out. So that's my sort of economic empirical approach to that. So if we return to, what would happen if the Supreme Court made various choices, I think it's good to, again, go back to those problems that prompted the Affordable Care Act. And they are the perennial problems in health policy: access, cost, and quality. And the Affordable Care Act really focused on them in that order. I mean, the first thing that they did was focus on access. Those are the major provisions of it. And they relate to insurance coverage. As Kitt has already mentioned, the expansion of Medicaid, the creation of the health insurance exchanges to reform the individual market that was badly broken, and the provision of subsidies for low-income people to buy health insurance coverage in those markets. And then, of course, the two, as Kitt mentioned, most popular provisions of the Affordable Care Act: the elimination of pre-existing condition exclusions and the provision that allows young adults to stay on their parents' insurance until age 25. And on a Vanderbilt call, I would be remiss in not saying that none of my students now can remember a time when these provisions were not in effect. They live in a world where they don't know someone who's been denied coverage for a pre-existing condition. And those of them that are graduating into a pandemic and a recession, if their parents have coverage, rest assured that they will be able to stay on that coverage. And so were the Supreme Court to overturn the entire ACA, the disruption would be unimaginable, and all of the young people that I encounter now would be dumbfounded. I thought I had to mention that, because again, the students that I interact with, this is their world. They know no world in which the ACA has not been in effect. So what did the ACA do related to cost? There were some questions from the audience about this, and they did make coverage more affordable by subsidizing it. It put into place numerous demonstrations of payment reform, which I'd be happy to talk about more during the Q&A. But a colleague in the Department of Health Policy, John Graves, and I have written about this in a journal and estimated the cost reductions resulting from that, and also from some direct changes in payment under Medicare. It also filled the donut hole in prescription drug coverage for seniors, which has also got to be up there if you look at the top three most popular provisions of the Affordable Care Act. And then in terms of quality, this was probably the part of the healthcare tripartite problems that the Act focused the least on, but it did advance, as Kitt mentioned, minimum standards for coverage and value-based payments. So, how well is it held up? In fact, this latest Supreme Court case is just the latest in a string of cases related to the Affordable Care Act, and it's not going to be the last. There's a whole string of other cases coming behind, but this is the last one probably that will attack the Affordable Care Act as a whole and threatens it as a whole. And despite this, it's held up pretty amazingly well, I would argue. There's tens of millions of more people with health insurance. Healthcare costs have grown more slowly over the past decade than they did over previous decade. These health insurance exchanges and markets are holding up well, despite the fact, for example, the individual mandate has been virtually abolished, and that there were many steps taken to undermine the functioning of those markets. So where are we now? Right now, we're obviously still in the midst of a pandemic and a recession where lots of people are getting insurance coverage through Medicaid or through subsidies. In fact, there's just been an expansion or an addition to the generosity of the subsidy schedule that's part of the American Recovery Act, and a reissuing of an enrollment period so people can sign up if they happen to have lost their job. And also over the past year, we've added to those 3 perennial concerns in health policy, I would argue 2 more that the Affordable Care Act does address in part, but not completely enough. And those are equity and public health preparedness. So on the equity front, we know that even though the Affordable Care Act has brought health insurance to millions more people and closed some gaps in health outcomes when people get insurance, there's still astounding inequality in healthcare access, delivery, and quality by racial and socioeconomic status in this country. And then second, the pandemic has laid bare public health preparedness and the need to invest, I would argue, in infrastructure to protect all of our health and our economy from pandemics in the future. So I'll end there.
Okay, thank you very much, all 3 of you, just wonderful. I have one quick follow-up, and then we're going to go to the questions for Professor Buntin. The most recent Recovery Act uncaps the 400% of poverty limit on the subsidies so that there's unlimited subsidies. Now, can you just say a word about what that was aimed at and what brought that on, what problem arose that this was designed to address?
So it doesn't make the subsidies unlimited, of course, but it does raise the income level at which people are able to access subsidies. And so there's a couple of reasons for that. One is that when in policy, we often talk about benefits cliffs being damaging. So once you reach that level, you just weren't eligible for subsidies anymore. And 400% of poverty, given how expensive healthcare is, there were still families that were very challenged to purchase health insurance, even if they were slightly above that 400% of poverty level. Another part of it was that family coverage was unaffordable to some people. Obviously, family coverage costs a multiple of what individual policy would cost. And so again, there was a desire to make family coverage more affordable to people at higher income levels when they had children they were also looking to cover.
Thank you very much. Now we're going to turn to Professor Wuerth, and let me read the question, and then Professor Wuerth will address the question. What injury has plaintiff suffered? Since the penalty was zeroed out, what actual or threatened consequence flows from non-compliance with the mandate? Why or why not does that satisfy Article 3 standing? If Congress passed a law that all Americans must buy broccoli, but there was no enforcement or penalty related to the law, would a plaintiff have standing to challenge the law, and why? And Professor Wuerth, there's a lot there, and we appreciate your being the leadoff hitter on these questions.
Thank you so much. That question absolutely warms my heart as a civil procedure professor who teaches procedure to many students, including, I believe, the person who submitted this question. So yay, civil procedure. And anyway, so the US Constitution only allows federal courts to hear true cases. And that's an interesting aspect of our constitutional system. Other countries have Supreme Courts that actually issue advisory opinions on pending legislation, right? Congress could ask the Supreme Court in Germany, would this statute be constitutional or not? We don't have that system. The Supreme Court, and in fact, the entire federal judiciary is limited to only hearing actual controversies in which plaintiffs have suffered actual injuries that can be redressed through the litigation itself. So this is it seems like a weird technical thing, but it's actually very fundamental to our constitutional system. And to my mind, it's one of the really interesting parts of the Affordable Care Act. So the plaintiffs basically have two kinds of arguments here. First, they say, well, there's still a legal requirement to buy insurance, or to take the hypo, to buy broccoli, right? You're still supposed to go out and buy it, even if there's no penalty. And so this legal duty puts some pressure on law-abiding people to actually do what the law says. And there were a bunch of hypos at oral argument. What if somebody has to fill out a job application and they're asked whether they've ever violated the law? Right? Do they have to put down like, yes, I violated the law because I didn't buy broccoli, or I didn't, or I didn't buy health insurance? So legal compulsion itself, this argument goes, produces injury even distinct from any specific monetary penalty. There are two problems with this argument. One is, on the facts of this case, there's a lack of concrete evidence that there actually are these kinds of injuries. In other words, we don't have a plaintiff that was filling out a job application and said like, oh my God, I had to write down that I had violated the law because I didn't buy my health insurance and therefore I didn't get the job. And at oral argument, there was sort of a concession, well, maybe that would actually be a cognizable injury, but we just don't have really, there's no evidence in the record on that in this particular case. There's also a line of cases that suggest you need some actual threat of enforcement, right? So in a variety of contexts, the mere fact that you might be afraid the government could come after you in some future time doesn't give you the right to preemptively challenge legislation. Instead, you wait for the government to come after you, and then you say, no, I'm not paying the tax, and you challenge it, that way. The other kind of argument is quite clever, right? And it goes like this. Let's say the individual mandate is unconstitutional and it can't be severed, and the entire Affordable Care Act falls. Many of the other provisions, like expanding Medicare, really do produce real effects and potentially produce real harm. And so therefore, the outcome of this litigation, right, actually has massive real world effects to people who are harmed, and therefore there's standing. So this is quite complicated, right? And Texas made a couple of arguments along these lines. It has standing because there's an increased cost to states when people enroll in Medicare, and there's a lot of paperwork required by the IRS, and so on and so forth. So this is weird because the actual part of the statute being challenged as unconstitutional isn't causing the injury, right? The idea is we're going to challenge the individual mandate, which is not injuring us, but then the whole statute's going to fall, and all those other things that are constitutional, they're injuring us, and they're going to have to go because the thing is severable. So that's kind of, yeah, that's like, it basically constitutionalizes the severability argument and makes it into an Article 3 argument about standing. I think it's unlikely that justices will want to adopt that theory of standing. But one of my first acts as a law professor many years ago was to predict confidently to a large group of people that the Supreme Court would never take Bush versus Gore. So on the prediction market, I'm out. So.
Thank you, Professor Wuerth. We now have Professor Carpenter, who's next up. And let me read the question that was submitted to Professor Carpenter. What are the side effects of people having health insurance when you did not have it before?
That's a really interesting question. Thank you, Jim, and for the questioner. So I'm going to take a crack at that, but if you had, I think it could go in many different directions. So I'd invite my other panelists to speak as well if they have thoughts. And certainly if you submitted that question and this isn't what you had in mind, I think you can reach all of us after and send us your clarifying thoughts and questions. So when I think of kind of side effects, I have three things that came to mind. And one actually shouldn't be a side effect, it's kind of a main effect. And that is whenever we think about insurance as economists, the reason you have insurance is for risk, is to cover, in this case, for example, financial risk and financial protection. So as I was mentioning in terms of kind of how we know what we know in the health economics and health services research community, it's based on the fact that these different parts of the ACA implementation offer these great kind of research designs for understanding differences across states over time in terms of the specific identities of when states expanded Medicaid, for example, or when young people, under a certain age limit, but not over a certain age limit, were able to access more health insurance. And evidence from these types of studies, I think, pretty clearly shows that access to health insurance really does play a really important role in financial protection. You see expanded access to insurance associated with lower rates of bankruptcy. You also just see kind of lower self-reported stress about money. And so this goes into improving things like life satisfaction. And there's a whole body of evidence and a whole research field looking at kind of cognitive load and how when people are really stressed about money, they just can't do other things, right? We only have so much kind of cognitive ability to handle different types of challenges in our life. And to the extent that expanded coverage under the ACA helps kind of smooth out those financial risks, that seems like a really important kind of side benefit, but also a main benefit. A thing that's kind of somewhat related to that, if you think about kind of trade-offs and risks in people's lives, is entrepreneurship. One, challenge and opportunity of the United States health insurance system being so strongly linked to employment is that when we have expansions that kind of sever that link or kind of weaken that link for some groups of people, there is quite a bit of evidence from different types of settings showing that expanded access to coverage through alternative sources increases people's willingness to open their own business, for example, or to go into business for themselves, or to be innovative and entrepreneurial in other ways. And so those are just a couple of examples of how kind of, downstream effects that you wouldn't maybe think of at first as being affected by expanded coverage. I will say on this entrepreneurship point, there was quite a bit of discussion and concern about major labor market effects from the ACA, people changing their employment, in all kinds of interesting ways. And my read of the research literature is actually that hasn't come to pass so much. There has been modest changes in people's work intensity, numbers of hours of work, but we don't see wholesale changes in employment and other types of kind of things that people were, very concerned about in terms of things like crowd out of insurance and those types of things. They have not come to pass, at least as determined by these kind of high internally valid studies.
Okay, thank you, Professor Carpenter. We now have Professor Buntin, and she can do several things here, but I'm going to pick one of the questions that she asked, and that is, what incremental changes do you see Biden and Congress making with the law? More subsidies for the payers and/or additional incentives with value-based care payment models? These are all kind of inside baseball questions, and they require some degree of kind of crystal ball gazing, but I think that Professor Buntin is very well situated to take a crack at it. So Professor Buntin, it's all yours. Thank you.
Yeah, thank you, Jim. So I will say that the Biden administration has already taken quite a crack at a number of different health policy issues through the vehicle of this Rescue Act, pandemic-related spending. So as you already mentioned, expanding subsidies, changing the enrollment period. There have also been many provisions related to payments, pandemic-related payments to healthcare providers, like doctors and hospitals and others. And there was an additional inducement offered to states that have not yet chosen to expand Medicaid, which is being dangled in terms of extra federal funding for the next 3 years if states chose to expand now. And there are clearly some states that are considering that. Indeed, our lieutenant governor mentioned that he was looking at the issue again, although I don't think that he had any compatriots in the House who were also similarly looking at it. So many health policy steps have already been taken. And one of the questions for later in Biden's term will be whether any of these changes are made permanent. So these additional subsidies, additional inducements to states to expand Medicaid. We shall see if those become permanent. And then there are other issues that may come to the fore, although again, this is my prognosticating. I think Jim is definitely the best Supreme Court prognosticator among us, in fact, probably in the entire country. So I won't venture into that territory, but on the policymaking territory, one of the interesting things will be whether, given this big rash of health policy related things in the Rescue Act, the Biden administration will return and try and do things, for example, related to a public option, other things that were discussed during the campaign. I would say that that is being fought out within the Democratic Party right now, and it's not clear where that will come out. On, however, the issue of things like value-based payment, that is normally way in the weeds, but in Nashville, where we have such an enormous healthcare industry, we really have we are the seat of investor-owned healthcare for the entire country. This is not an academic issue at all. So I will say that from the nominees chosen by Biden to lead the Centers for Medicare and Medicaid Services, and also the Center for Medicare and Medicaid Innovation, which is spearheading the value-based payment. These are people who are going to want to make changes. These are not people who are going to want to rest on the laurels of what has been done before them. So I do expect more action in those areas.
Great. Let me ask whether any of the panelists would like to pose a question based upon the presentations to any other panelists before we move forward. Ingrid, Professor Wuerth?
Yeah, I had a question for you, Dr. Buntin, and just when you're in your initial presentation, when you're talking about how your students can't imagine this world other than the Affordable Care Act, I thought that was interesting, and it made me wonder, gosh, what if the whole darn thing got struck down? I mean, wouldn't Congress just reenact it? And maybe maybe with some changes that the challengers to the Affordable Care Act wouldn't actually like. It's just an interesting moment I think we tend to think in I do in very inertial terms, right? We've had the Affordable Care Act and therefore we should kind of path dependent, but gosh, maybe even for progressives who favor really dramatic healthcare reform, maybe if the Affordable Care Act got struck down, we just, see something, a lot of it's very popular. We might see something really big and really different. I don't know. I just thought I'd throw that out there for your comments.
I mean, there have been some estimates of, what immediate effects could be, and they include tens of millions of people losing insurance, as well as an enormous host of other issues. The Affordable Care Act was a large piece of legislation. In fact, one questioner asked a question about biosimilars. You can say, well, we haven't mentioned anything that sounds like biosimilars yet. I think that's one of the reasons why I fear I'm treading on Jim's prognostication territory, but because there's such a wide range of things, biosimilars really have nothing to do with the individual mandate. And so it's one of the examples of why it seems like the court would be unlikely to find the entire thing unconstitutional, because it seems like you should be able to sever, for example, things like the provisions relating to biosimilars from the rest of it. And I think in the case of things like pre-existing conditions, things like the biosimilars, and a whole lists and lists of dozens of other things, Congress probably would try and act very quickly to reinstate them. Nonetheless, they would be so massively disruptive, and there are such massive fiscal implications. I mean, literally the changes to Medicare alone probably easily amount to a couple $100 billion that doctors and hospitals could say they're owed. There just have to be a transition plan. There's no way it could happen overnight when the court ruled.
Professor Carpenter, do you want to respond to that?
No.
Okay.
I defer to Dr. Buntin on all such things.
Fair enough. Yeah, on the question of what is likely to happen, of course, no one really knows what's going to happen. And the lower court, as Professor Wuerth stated, held the individual mandate was unconstitutional, but it basically said there was not enough evidence about the intent and punted on the question of severability, what was to stay and what was to go. And so it sent the case back. Uh, I really don't know how to call this. There's part of me suggests that the Supreme Court may want to send the case back to and punt as well, so that it doesn't have to decide what stays and what goes. But from and I didn't listen, unlike Professor Wuerth, I did not listen to the full oral argument. But my guess is that there are enough of the justices who want to resolve this question that they're not just going to send it back and say, try it, try your hand at this again. Although I think in some ways, with the court under so much pressure, that would be the path of least resistance, would be for the court not to make a decision at this point, but send it back to the trial court. That's a typical argument. I don't think that's likely going to happen in this particular case. I think that there are probably 5 justices at least who are invested in reaching some resolution of the case at this point. And what that resolution is, one doesn't know, but I think it's not likely, in my view, that they will strike the whole thing down. On the other hand, there's always on the other hand, and when I do this, I kind of quickly run out of hands. But on the other hand, you had 4 justices the first time around wanting to strike the whole thing down. And 2 of those 4 are gone. And you don't know what the 2 new justices are going to do or say. So again, it's just hard. It's just hard to know. Does anyone have another question they want to pose to another fellow panel member? Okay.
Jim, I could add just a few thoughts to what you've just said about what might happen. I do think it's unlikely they'll just send it back down, because that's what the Fifth Circuit did. And so it would have wasted a lot of time to have granted cert, had rounds of oral arguments, and then just decide that it should go back down to the trial court, which was the procedural posture that it was in to begin with. So I tend to agree that kind of the optics of that are not great. To have, right, the court doesn't have to accept a case. It grants cert as a discretionary matter, and to have accepted certiorari here and then simply take a year and a half and then have a resolution that's basically what the Fifth Circuit was doing in the first place, I think is just not great. And remember, those 2 justices have turned over, but so has Justice Ginsburg, and so we don't know how that vote would go either. So there's been a lot of turnover on the court, and that makes it even more interesting.
Yeah, Ingrid, at the risk of kind of going one step too far here, let me respond to your points, which are all very good points, and I don't disagree with them. But there are 2 separate cases that are consolidated. One is California versus Texas, and that was brought to challenge the challenge itself, the Texas challenge. And then there's Texas itself that is challenging the federal government, and where the Trump administration basically had agreed with Texas's position. When the case went to the Supreme Court initially, cert was granted on California versus Texas, on California's claim. And that only requires 4 votes to grant cert. And I'm guessing, and this is just speculation, I can't prove this, but my guess is that the justices who were favorable to California's position were the ones who granted cert, counting on Chief Justice Roberts to vote with them again and save the law, basically. Texas filed a pleading and said, look, if you're going to hear California's appeal, you at least should hear ours too, so that our issues of severability are on the table also. And you could see another block of justices, a more conservative block, saying, if we're going to hear California's appeal, we should hear Texas's appeal too, and let's put the whole thing on the table. One of the justices, one of the 4 who I think voted to grant California, was Justice Ginsburg, who's not on the court anymore. And so if you ask me, if I'm asked what I think is would be the best outcome in terms of the institutional position of the court would either be to affirm the trial court for, despite what Professor Wuerth says, which is very reasonable, good, and I don't disagree with it, but in terms of political position of the court, would kind of push this down the road where the court wouldn't be ruffling feathers. It would saying like, huh, why did you go through all this to come out with a non-decision? Or the other thing, which is what I really think should happen, is there's a tradition where matters are different from what the court had thought in the beginning, would be to dismiss the writ of certiorari as improvidently granted and not to render a decision on the merits. This is very much in the weeds, but I'm not sure that that's likely to happen either. But I think that would keep the court from getting its hands muddied up and dirtied up by saying, oh, you're a political court, you're this, you're that. This would basically say to the lower courts, you all figure this out. We're out of here. We're going to wait for a more developed record and a more developed set of principles before we get back into this. I don't know that. Anyway, that's just a different set of circumstances. If I were on the court, that's what I would be lobbying for. But I don't think that there's very many votes for that either at this point. Okay, we have very little bit of time, but let me see if I can. There was a question that was raised, and this is for everybody, about whether administering healthcare on a national basis is a proper role for government and within the enumerated powers of the Constitution. Should the federal government be involved in this or not? And to some extent, the court in 2012 addressed that question, but there's an awful lot of federal involvement at this point. But what do people think? Is the federal government taking too big a role here? Is it moving in the wrong direction? Professor Wuerth suggested that if this case is struck down, that there could be a push for single payer or something even more governmental involvement. What's the right balance, and are we there yet at this point? Professor Buntin, do you want to start that conversation?
Sure. Well, it's hard to know exactly what the questioner meant by a federal role. Obviously, the federal government runs the Medicare program. The Medicare program covers virtually everyone over the age of 65 and is very, very popular. In fact, it's so popular that people refer to it with Social Security as, third rail of politics. Don't mess with Medicare. So the federal government has a clear role in provision of healthcare in, every state and county across the country. It plays a major role in funding, through various programs, roughly half of the healthcare delivered in the country. And so the question of whether that role should be larger or smaller is one that I think our politicians debate daily. But whether it should be zero, I think, is a settled question. The public loves Medicare, wants to keep it, and does not want to fear, referring back to some of the things Kitt said, they don't want to live with the fear that they will either be turned away when they need care or that it will bankrupt them if they get a dread disease. And so I think that's where we are as a country. Going much further than that, we'll have vast differences of opinion on them.
Kitt, do you want to try your hand at that question, or just?
Yeah, no, I would just say that there's a range of economists with a range of different views about market-based solutions relative to more heavy-handed command and control type interventions. But as you said at the beginning of this forum, there are kind of market-based problems that some of these programs were intended to fix. And so a lot of the disagreement among economists about kind of more market-based versus more kind of heavy-handed ones have to do, a lot of the sources of disagreement have to do with things like paternalism, where the two sides really disagree a lot, but there's actually much more agreement about kind of fixing the market-based problems that you described at the beginning, and that kind of generated much of the impetus for the ACA. So I'm in agreement with Dr. Buntin.
Yeah, my little notes here say it's time for me to make some closing comments, but I've pretty much said what I have to say. So I'm going to just ask another question, and that is, in the Recovery Act, the Biden administration took the caps on the subsidies off for 2 years temporarily, and I think part of the policy that was being addressed is that the market did not collapse, but it did have losers. And the losers were those who were making about $100,000 a year, right at the top of the cap. And so when you play pin the tail on the economic donkey, the tail was being pinned on those folks who make family of four about $100,000, and a pretty big cost increase for that group. But the market, the subsidized market, had survivability, and that was not fully appreciated at the time. The question I have is, what about at the low end? Um, because Medicaid is now optional, the reality is that some people, it's a problem in Tennessee, some people have too much income to qualify for Medicaid, and too little income to qualify for subsidies on the exchanges. Curious why that issue wasn't addressed or isn't being addressed. It would seem to me that there's a strong claim for addressing or redressing that imbalance that comes as a result of the Supreme Court's decision in 2012. And let me quickly say that I bear some responsibility for that because I worked on the argument that made Medicaid expansion voluntary rather than mandatory. So what do people think? Is this going to happen, or is there a political game that's being played to not solve this problem or address this problem because it'll create more tensions in the system? Any thoughts on that?
Well, there have been some hints, and I will say they're in the category of hints and rumors, that there are people within the Biden administration who are, well, obviously people are concerned about the group you described. It is a strange situation when you make too little to be subsidized, right? And so the question is, would the added inducements in the pandemic-related bill cause more states to expand Medicaid, thus covering the people who are in that gap, or would further steps need to be taken? And so apparently there is some consideration within policy circles of expanding the subsidies on the exchanges downward in the states that don't elect Medicaid expansion. This would create a lot of differences across states. And the truth is that it is a much more efficient way to build on existing systems and sets of relationships with insurers, for example, in the state of Tennessee, that cover low-income populations, to do the Medicaid expansion. It would be a lot more administratively tricky and more expensive to do it the other way. So there's a little bit of a standoff there.
Well, we're near, my clock shows 12:59 and the witching hour is 1 o'clock. So I'm just going to end by saying this. Those of you who are in Tennessee or you want interest in the issue should keep your eye on the waiver that Tennessee received back in January, which may be redone by the Biden administration. We don't know. Those waivers tend to have some staying power. And there's a group in Tennessee, the Tennessee Justice Center, has filed suit in federal court in the District of Columbia challenging that. So that to me is kind of the next phase of where attention will be, is whether that waiver, to my way of thinking, what the waiver does is it transfers the Children's Health Insurance Program model, the CHIP model, transfers it into a Medicaid model, which is a form of capped entitlement. And so the question is whether, in my view, the federal government can transfer the CHIP model into the Medicaid model by use of the waiver. Thank you all for being with us. Again, I'm Jim Blumstein, and I want to thank our wonderful panelists, Professor Ingrid Wuerth, colleague of mine in law school, associate dean, and I didn't say an award-winning teacher this time and many times. Professor Buntin, Medical Center Chair of Department, just doing outstanding work in developing that and making Vanderbilt a kind of a leader in the area. And Professor Carpenter, a leading health economist who has presented very strong information, very important information, and a leader in his field of health economics. We're very privileged to have these three people at Vanderbilt, and I'm privileged to be able to moderate a panel that has those outstanding stars, really, national stars on the panel. So thank you all for being with us, and I will call it a day.
Thanks so much for the
Dr.
invitation.
Bronson.
Thanks, Jim. Thanks all.